Hi, my name is Jen Duke, and this is Module 8, Legal Aspects of Teacher Evaluation. So to summarize the documents that were presented to us in this module, I want to start by talking about what teacher evaluation is. And it's basically the formal process that a school uses to review a teacher's performance and effectiveness. This is governed by state laws and can involve classroom observations, usually by the principal or administrator, samples of student work, lesson plans, rubrics, checklists, assessments, things like that. So how and why are teacher evaluations evolving? An analysis showed that most reviews of teachers didn't necessarily distinguish between skilled and low-performing teachers, and that a proficient teacher in one state may not match a proficient teacher in another, and that revamping evaluations could help teachers get more effective feedback, which would then help them grow in the profession and help our students achieve more success both personally and academically. Then we learned about the Every Student Succeeds Act, and some of the provisions that are a part of the ESSA are that this does not require states to use student test scores for evaluation. And this was a big piece, is that this feeling that assigning students' test scores and achievement data to a teacher's ability to be labeled as proficient didn't feel like the right way to evaluate teachers. Under the ESSA, it also states that the Secretary of Education will not be able to prescribe the teacher evaluation systems for states, and that states should develop their own goals to gauge school performance. And then that states can design and implement their own evaluations and support systems of their teachers based on their population and needs. As part of bargaining and evaluation connected to the ESSA, the state may be able to negotiate aspects of the evaluation system, and as part of the implementation process, it is a requirement that evaluation systems be funded, fully developed, and validated, and that teachers have the opportunity to be trained. Improvement plans and due process rights have to be considered when a state develops an evaluation plan, and that it must align with the contract. So I work in the Blue Valley School District, and our evaluation process is very similar to what could be considered a clinical supervision cycle. We have a pre-conference with our assigned administrator, either the principal or assistant principal. I work in a middle school. And during that pre-conference, we share what the lesson is going to entail and talk about some specific look-fors that could happen in order to receive the most effective feedback possible. Then there is a scheduled observation where the administrator usually scripts the lesson, talks to a few students, asks some questions, and then a post-conference has to be scheduled within 5 days of the observation. During that post-conference, there's a conversation about the lesson. There's opportunities to talk about strengths and areas of growth. And all of this is documented. There are also pre- and post-reflection documents that have to be completed by both the teacher and the supervising administrator. And those documents are housed on My Learning Plan. It's where we keep track of all of our professional development points, and it's the way that we communicate with the state as far as teacher certification goes. So where can a teacher in our district go for support? Each of our buildings has an NEA representative. And if it were to be the case that a teacher felt like things weren't going fairly or, not tipping in their favor as far as getting the support they need, they can request that this representative be present at meetings with supervisors. And this representative is a direct resource within the building and can also point them in the direction they need to go if things, continue to escalate in a manner that's not best for the teacher. This can also be reflected in the post-reflection documents. A teacher can, as they finish their post-reflection, put into that document that they felt that it was inaccurate, and that they can also request another evaluation. And all of this you would want to alert the NEA building representative. And then lastly, if a teacher feels they're unjustly being let go, they can utilize the NEA or hire a lawyer And what I know about our district is that any teachers that have been let go have a lot of times been given the option to resign over being fired so that they can find a job in another district. So a legal case connection, this court case has to do with Clark County Schools in Las Vegas. It was filed in June of 2015. And the alleged violation was that there was a 2011 law that allowed districts to fire a tenured teacher who had 2 consecutive annual ineffective evaluation ratings without due process. And the school district asks for dismissal of the case on the grounds that teachers who were tenured before the law went into effect have vested contractual rights and can follow the hearing process. So my reflection about how I will ensure that I'm following legal issues related to evaluations when I'm an administrator is, first, I'll put in time to work to fully understand the district framework from the supervisor's end. I feel like I understand it from the teacher's side, but really to make sure that I understand the framework for supervision and evaluation to begin with. And then certainly just ask questions. When I'm not sure, talk to a mentor, talk to another supervisor, another principal in the district. I would also involve human resources at the earliest sign of an issue, whether it be in an evaluation with a teacher, just so that I make sure I'm following protocol and that the teacher's rights and mine are protected. And just, I would need and want to learn more about NEA and contracts and negotiations, just to make sure, again, that I have a full understanding of the entire cycle and the big picture. So thank you very much. And I learned a lot during this module about the legal aspects of teacher evaluation.